Good morning, everyone. My name is David Friedman, and I've been asked to speak to you about estate litigation and probate history, as well as a few other minor points. And if I've done this correctly, you'll see that there's a PowerPoint presentation on the screen. I have also prepared some lecture notes, which I'm going to use or I'm going to refer to, and I hope they've been provided to you. And I'll provide a copy of these slides to Ian and Susanna so that they can pass them on to you as well. Um, this is an interesting topic, estate litigation. And I think that part of the problem is that there's a lot of technical law and there's a lot of history, a lot of very particular terms of art that we use, and that sometimes the technicalities are intended to provide a certain amount of predictability and precision, but they do represent a bit of an entry to entering into the or a barrier to entering into this area of practice. And once you get beyond that, it's all fairly simple. Really, we have a model of law that is developed over a very long period of time, and it's extremely stable. Not only that, there's a great approximation of laws between the common law jurisdictions that derive their law from English law. So that I don't think that it's untrue to say that an Ontario lawyer practicing in this area would have very much difficulty practicing in an Australian state or in the United Kingdom or England and Wales, or probably even some of the American states, which are a little bit different, especially in terms of language. But the model of law that's developed works really, really, really well. And so the trick is to understand the contours of the law, the overall model, and the technical terms that are used. And once you get beyond that, it really does get to be pretty easy. And all of the various speakers that are going to be speaking to you during the course of this program will be able to lead you through all of these various areas. I've been asked to do things at a broader level, and I'm hoping that whatever I say and whatever's in the lecture notes are of some utility to you. So let's get to it. Oops. This is what I want to talk about this morning. First, understanding some fundamental concepts and fundamental terms. Once you get beyond this, things get a little bit easier. The court has different jurisdictions, special jurisdictions in this area of law, and it's important to be able to understand what the nature of those varying jurisdictions are. Then I would like to talk about probate proceedings, probate applications in simple form, probate applications that are subject to a notice of objection and there's contested proceedings, a little bit on the procedure for proving wills, although other speakers are going to address that in great detail. And I would also like to talk a bit about the law of limitations. Okay, concepts and terms. So I'm going to make reference to some of the points that I've set out in the lecture notes on pages 1 and 2 and 3. And my apologies if you already know this. My apologies if some other person has spoken to you about this before, but maybe it's just a little bit easier for us if I start right at the basics. It's important to understand what a will is, and it's important to understand what probate is, and not to confuse them. A will is a legal instrument, and it's a really special form of legal instrument. Normally, we consider bilaterally constructed things like contracts. Occasionally, we deal with unilaterally constructed documents involving promises or something like that, documents that are often under seal. Those documents talk to a state of affairs that exists at the time that the document is created, at the time that the document is executed. They're not future looking on the whole. They tend to be backwards looking. A will is not that. A will is a document that sets out what a person, a testator, intends with respect to their property after their death. It can also do some, other things like appoint temporary guardians for children. But on the whole, we're talking about the transmission of legal and equitable interests from the estate to one or more beneficiaries. A will to be valid has to be compliant with formalities. And as I'm sure speakers will explain to you, we have moved from what's called a strict compliance jurisdiction, where if you weren't strictly in compliance with all of the formalities provisions in the Succession Law Reform Act, the will wasn't valid, to essentially what the law calls a substantial compliance jurisdiction, where a judge has a jurisdiction to hold that a will is valid, notwithstanding the fact that there may only be one witness, for example. And that's a real major change in the law. But for our purposes, we can just say that a will is an instrument that has to be made according to the formalities provisions of the Succession Law Reform Act. Beyond that, what we really are testing when we consider whether wills are valid or not is whether this document represents the deliberate or fixed and final expression of the intentions of the deceased. Is this document intended by the deceased to be given effect after their death with respect to their property? If we're unsure about that, then it's not a will. And so there's a lot of older cases that deal with things like notes to a person's lawyer, which is the Bennett and Toronto General Trust Corporation case, where you're not sure whether, in fact, whether this note to the lawyer was intended to operate as a will or not, or whether this was just instruction. So we're really fixated in the law of succession to ensure that wills that are admitted to probate or that we use to administer estates are, in fact, the fixed and final expression of the testamentary intentions of the deceased. Beyond that, there is something that's a bit different with respect to wills compared to other kinds of instruments. One is they're revocable. So a person can revoke their will after they've made it at any time. Now, there may be some parts of that will that might be binding on them, notwithstanding the fact that they've revoked the will. And at some point, there may be some discussion of mutual will agreements and things like that. But a person can revoke their will anytime they want. Second, a will is what we call ambulatory. It will speak to property that is not necessarily owned by the testator when he or she made their will. And it may be in respect of people that don't yet exist when he or she made their will. So you might make a will today in respect of a residence you don't own in favor of grandchildren you don't have. And that is perfectly proper because a will is future looking. It's ambulatory in that sense. And so a will is quite a special document, unlike any other document, and as a result requires different kinds of rules to test validity. This is really important, and sometimes it's surprising that even in practice, some lawyers don't recognize the distinctions between what a will is and what probate is. A will is a document. Probate is a process. Probate is a process by which a will is declared valid by a court. Probate is important because the estate trustee is going to be transacting with third parties, including beneficiaries, and everyone has to know that they have authority over the assets. A will creates what we call an in rem right in assets. That is a right in the thing itself. So probate is important because it is the authoritative determination that a will is valid as a matter of law. Authoritative. Everyone knows that the will is valid. Everyone knows that transactions that have occurred on the strength of the will are going to be valid as well. In the lecture notes on page 3, I've set out, if you've never seen one before, certificate of appointment of an estate trustee. So just a regular court document under seal that's provided to the applicant after the successful application for probate. Probate historically is in respect of wills. And one of the things that we've done in the last number of years in Ontario is we've changed the language and made it a little bit more accessible. So it used to be, if we wanted to be technically correct, we would talk about executors being appointed under wills and administrators being appointed by the court where a person dies without a will. That is to say that they die intestate. Now it's those terms are used a little bit more loosely, and we don't have different kinds of certificates that are the end result of a successful application where there's a will or where there's not a will. We talk about a certificate of appointment of a state trustee with a will or without a will. Now, this is significant as well. And again, it's important to understand that probate is not a process that gives a person power outside of the circumstance where there isn't a will. If a person dies without a will, that is to say that they die intestate, then the person that's going to be administering their estate gains their authority to do so by the issuance of the certificate of appointment. They take their authority from that certificate of appointment, which means that until that certificate of appointment has actually been granted, no one has legal authority to deal with that estate and its assets. I mean, certainly people will, and if necessary, there are ways to hold them to account through the law of trusts, through a device that we call a trustee de santord. But with wills, it's not probate that gives the estate trustee his or her authority, it's the will. And so if a will is not submitted to probate, that's not to say that the estate trustee does not have the authority to administer the estate on the strength of the will. Really, you only need probate in order to give assurance to a third party that they can deal with the estate trustee and be bound in a transaction. So the estate trustee must have probate to deal with certain kinds of assets, normally land outside of a first dealings exemption in some cases. But on the whole, you need to have probate for the estate trustee to deal with interests in land that were held by a deceased at their death. You don't need probate and the issuance of a certificate of appointment for an estate trustee just to deal with personal property. So if it's the case that the deceased dies and holds a series of assets that you don't need probate for in any way, then you don't have to go to the cost and go through the process of applying for a certificate of appointment. It may be if the assets are substantial enough that the third party that's in possession, like a bank, will still insist on probate to ensure that there's no liability by providing the assets to the estate trustee. And banks have certain limits over which they'll demand probate. And until you get to that limit, all you need is the will. So the point that you should take is that probate is a process for validating wills, but it's not always necessary to validate a will to ensure that an estate trustee that's named under that will has the authority to administer the estate. It's the will itself that provides the estate trustee with authority. So again, Why all the fuss? Because we're talking about rights and property. We want estate trustees to be able to transact with third parties and for the beneficiaries of the estate to have an assurance that those transactions are unimpeachable, for those third parties that are transacting with the estate trustee to know that as those transactions are unimpeachable, and to allow the estate trustee to make other decisions which will be binding in respect of the administration of the estate going forward. So probate, the judicial validation of a will as valid, sets up the authority of the estate trustee and then makes it those further transactions and decisions unimpeachable, provided that they're obviously within the authority of the estate trustee to administer the estate. Hopefully, we're on the same page so far. Okay, so let me talk about the jurisdiction of a court. In the lecture notes, on pages 3, 4, and 5, I've tried to give you a little snapshot of how the law has developed. Our law, the law in Ontario to deal with succession, comes from English law. And if I'm not wrong, either the first statute of Lower Canada or maybe the second statute was the adoption of English probate law. Our probate law comes from English law. And that law is actually really interesting. I mean, if you're interested in legal history, the history of English succession law is the history of English law. There's some scant evidence about wills that existed prior to the Norman conquest in 1066, very little, but there are some parts of that pre-conquest law that still are in our law, specifically the rule of the executor, surprisingly enough, comes from Saxon law. Afterwards, you have the development of English law. You know, that you have uh, French law that comes in after the Norman conquest of a form. There was probate law for a long time, or succession law for a long time, was partially secular and partially canon law in the United Kingdom, and so that the forms and the law of the Roman Catholic Church existed together with both the common law and early equity in England as the law began to first develop medieval forms of landholding, you know, primogeniture, and then release all of those forms in favor of something modern. And statutes began to be created in the early 17th century to give form to this area of law. And, you know, it develops on and on and on and on. And so you can see how English succession law changed over time to reflect the nature of the economy, like from an agrarian society to an industrial society, from courts that were ecclesiastical courts in some cases to completely secular courts, from very discretionary decision making by judges, something that really conforms to what we would call the rule of law today, and you know gives us this really developed model of law. It develops in a weird way, but the way that it developed is you know, it's pretty complicated, but on the other hand, it works, you know, very well. It's a very stable model of law. And so I'm not going to go through what I put into in the lecture notes, but I put it there just so you have, you know, some idea of how it is that some of these doctrines have arisen and some of the jurisdictions of the court have arisen. So I'd like to talk about the functions of the court or the jurisdiction of the court. And this is, again, an area where the law does differ in this area because normally when we think about a court's jurisdiction, we think about the court's normal adjudicative jurisdiction. In matters of probate, the court has a special jurisdiction, a unique jurisdiction. and that's an inquisitorial jurisdiction. And if I could direct your attention to the lecture notes on pages 5 and 6, I've given you some of the dicta of Mr. Justice Cullity in a case called Otis and Otis, which is about 20 years old now, in which Mr. Justice Cullity explains the nature of the court's jurisdiction. A court has an inquisitorial jurisdiction in respect of wills. That is, the judge can inquire into the validity of the document regardless of whether there's a notice of objection or not. This is why that if you bring a will to the court in an application for probate, and there are some problems with the will, a judge is perfectly within his or her jurisdiction to mandate that a hearing be arranged and that evidence be brought to court and that the applicant prove that the will is valid. And the reason for this is it goes back to the nature of probate itself. That is, to recognize that a valid will sets up proprietary rights in the hands of an estate trustee over the assets of the estate. That is, the will creates in rem rights. If the point of probate is to assure everybody in the world that this will is valid and that transactions that are entered into with the estate trustee are unimpeachable, then it can't merely be a matter of applying for probate and automatically you get probate. In appropriate circumstances where a court has a suspicion that something is wrong or there's a need for clarification on some point, then the court can inquire into the validity of the will. And if the historical part of this, it does go back to ecclesiastical law, in which canon law allowed for, at that time, it was normally the local bishop or the bishop surrogate to be able to cause an inquiry before the ecclesiastical courts into a will. None of that really matters anymore. But what we still have is a different jurisdiction in respect of wills, so that even in contested proceedings, a court can still cause inquiries into areas that the parties don't contest, or if the parties, settle and say that the will is valid, but the court still has a concern, there still may be an inquiry into the validity of the will notwithstanding. That's really unique to the law of wills. I mean, this is a jurisdiction to the court that arises in the hands of the court, rather, which is completely independent and can be exercised by the court regardless of what the parties have to say about the matter. The court has its normal adjudicative jurisdiction as well. Where there's a will contest, which is to say, where there's been a notice of objection that's been lodged, and now the matter is going to be brought into court to determine whether those objections are valid or not, the court still has a normal adjudicative jurisdiction where the court sits as a neutral umpire between the two sides, finds the facts, makes holdings of law, and applies the law to the facts, and that the scope of the contest will be determined by the parties and their pleadings, et cetera, et cetera. And so it's not always necessary for the court to exercise its inquisitorial jurisdiction. It's actually usually pretty rare for the court independently to exercise its inquisitorial jurisdiction. Normally, it just has this adjudicative jurisdiction that we're all familiar with. I should say there's actually another jurisdiction which is the court's advisory jurisdiction, which I've noted in the lecture notes somewhere. After the will has been admitted to probate, on the strength of Section 60 of the Trustee Act, a trustee as a fiduciary can come to court and ask the court for the court's advice and direction on a contemplated course of conduct, and that's within the law of trusts. But an estate trustee is a trustee, and that special advisory jurisdiction of the court, which is really unique to the law of trusts, also comes into the law of succession, but not within the law of probate, so to speak. Okay, Um, there's some old terms, common form and solemn form of probate grants. Um, this is pretty easy. Um, common form and solemn form mean uncontested and contested proceedings. So common form really just means that probate is going to issue as an administrative exercise. An application is made to the court together with the will and the affidavits of execution, and the application form is submitted to the estates clerk at the court. The estates clerk looks at the will and uses a manual that's been created by the Ministry of the Attorney General. If there's nothing in that manual that causes a concern that requires the application to be elevated to a judge or returned to the applicant, and there's no notice of application that's been lodged, then probate will issue as long as the will appears to be compliant with formalities. And if the will is compliant with formalities, it's presumed to be valid. And then it's just an administrative exercise. So common form issuance of probate really just is the normal issuance of probate where there's no contest and there's no real concerns. Solemn form means the will has to be proven by evidence. Now, many, many years ago, the immediate family of the deceased had the right to have a will proven by solemn form, which is not done anymore. Now, proof of the will by evidence is either because the court requires it as an aspect of its inquisitorial jurisdiction, or more conventionally, because somebody objects through a notice of objection. And so the application and the notice of objection end up being the pleadings. And now the contest is going to be held in court, and now the will is going to have to be proved by evidence before the court in most cases, although that's a little bit complicated as well. And I'm sure somebody's going to talk to you about how evidence works in probate contests and specifically the doctrine of suspicious circumstances, which becomes relevant to solemn form proceedings. I have given you a couple of slides. Um, this is the process for a will being contested. It's pretty simple. Now, it might be the case that the will contest takes place on the strength of a statement of claim and a statement of defense, as in conventional litigation, but that's not normally the case. It can happen, and it is appropriate to happen in certain kinds of circumstances, particularly if there's allegations of wrongdoing or fraud or undue influence. It might be appropriate to have a statement of claim, but normally probate proceedings arise by application and are conducted by application. And so in the slide I've noted, and in the lecture notes, noted the principal rules that you have to be familiar with for these kinds of contests. The rules of civil procedure, Rule 74 and Rule 75, deal with estates matters. They're basically the old surrogate court rules that have been continued within the rules of civil procedure as we have them now. Rule 74, on the whole, deals exclusively with uncontested points dealing with probate. Rule 75 exclusively deals with will contests or contentious probate matters before the court, including some matters that don't specifically have to do with probate as well, but on the whole is dedicated towards probate. So on the left side of the slide, I've noted the principal rules that you have to be aware of in this area, and I'm sure that speakers will take you through them in some detail. And on the right side of the slide, I've just shown you how this normally works. You go from an application to a notice of objection. Like any kind of application, there's normally then a motion for directions. Where something proceeds by a statement of claim, there are, a series of rules that set out all of the default provisions dealing with discovery and all of the rest of it. And the rules of civil procedure in applications, instead we use a motion for directions and orders for directions to set out procedures moving forward, production orders against third parties, the appointment of an estate trustee during litigation, whatever the case may be. And again, there might be an opportunity for multiple orders giving directions to be required during the course of the litigation. Eventually, there's application records and responding records that are delivered. Then there's cross-examinations, and then normally a pretrial and a trial. Depending on what part of the province things are taking place in, there may be mandatory mediation, for example, in Toronto. And as with all litigation, there may be motions that are brought at any time. There may be an opportunity to have the assignment of a case conference judge to make everybody's life a little bit easier, although that's increasingly difficult depending on where in the province this is taking place, just because of the lack of judicial resources, and there just isn't case management judges, unfortunately, always that are available. So as you go through this program, this whole process will be the subject of presentations, which will make it a little easier to understand. So the last thing I want to talk about is limitations, which has been in the news of jurisprudence, if I can put it that way, of late. Limitations, as everybody knows, are time bars. You only have a certain amount of time to sue. The law of limitations sits alongside an equitable doctrine called laches. And laches predates the contemporary rules of civil procedure and predates the law of limitations. And this is just an equitable device where one party has made representations that an existing state of affairs is acceptable and allows another party to act to their prejudice based on those representations, and then becomes unfair for the party making the representation to resile from their position. And so this equitable doctrine of laches basically exists to allow a court to stop the proceedings. In essence, it's a form of estoppel. Will contests. Will contests are easy for the law of limitations. At one point, we weren't sure if there were limitation periods at all. Very on in English law, the close kin of the deceased had 30 years to dispute the will. And that was mainly because it was involving landed families, and it made economic sense within the context of that time. Now, the law of limitations mainly reflects that people don't sit on their rights forever. In the lecture notes, I haven't dealt with this really at length, but I've set out on page 10 some of the provisions from the Limitations Act. I mean, we're not doing the law of limitations. I assume that you know the basic points. In the last 10 years, the law of limitations in Ontario has developed to deal with will contests, and the law is now developed such that it's beyond argument that there is a limitation period on will challenges where a party seeks what's called consequential relief. So this is the legal case which has developed a jurisprudence of its own. There is a limitation period of 2 years from the date of death. So you've got 2 years to be able to bring the matter into court to challenge the will. Beyond that, it is possible to institute a will challenge after the 2-year period, but only where the remedy that is being sought is a declaration. That is where there isn't an attempt to oust the estate trustee and then have the will or have the estate distributed on the basis of another will. If it's considered important for whatever reason to note that the will subject of probate is not valid, then a declaration can be obtained at any point, because there's no time limitation on declarative relief under Section 16, sub 1, sub A of the Limitations Act. Under the Limitations Act, Section 4, there's a 2-year period, which legal tells us is enforceable against estates. That is subject to reasonable discoverability, and also subject to the related concept of fraudulent concealment, so that the time bar might be adjusted based on discoverability or fraudulent concealment. But for our purposes, we just know that it's a 2-year time period. And in the lecture notes, I've given you on page 11 and 12 and 13 some of the dicta of Madam Justice Greer in the Liebel case respecting those limitations periods. There is a new case that's out, Ingram and Kolinich Estate. I think that's how it's pronounced. My apologies if I'm getting it wrong. This deals with an interesting question that arises in respect of land, but I think that the case, stands for a proposition that goes beyond that. Land is dealt with differently than other assets for lots of reasons. When the Limitations Act, the new Limitations Act, 2002, came into effect, part of the old Limitations Act dealing with land was hived off, and a new statute was created called the Real Property Limitations Act. And under that statute, there is a 10-year limitations period in respect of land. So what do you do in respect of estates? So there's 3 sets of statutes that are important in dealing with limitations periods. One, there is the regular Limitations Act 2002, which would seem to deal with conventional limitations periods for actions by or and against an estate. For example, in something simple like a breach of contract. You want to sue the estate because the deceased breached their contract. You would have 2 years from under the normal limitations period from the time presumptively the breach took place. And after that, the limitation period has expired and you can't sue anymore, subject again to reasonable discoverability. What do you do, however, when you have a limitation period that arises by one of the other 2 statutes, which is the 10-year limitation period in the Real Property Limitations Act, or the 2-year limitation period under the Trustee Act? And the 2-year period under the Trustee Act does not admit of reasonable discoverability. Fraudulent concealment is a little bit different, and there are some opportunities, even where there isn't reasonable discoverability, to use fraud or fraudulent concealment. But that's a different topic, I suppose. But you've got this problem of how to deal with land, which might have a longer limitation period, but at the same time, you have a policy of administering as estates, hopefully within a year, maybe a year and a half or 2 years. So you want to have these estates administered more quickly. A decision dealing with claims against unjust enrichment, or on the basis of unjust enrichment in respect of interests of land, there's a case called McConnell and Huxtable, which was a judgment of the late Mr. Justice Rosenberg. And I think this decision may have been the last decision that he wrote before his untimely death, in which the Court of Appeal confirmed that 10 years is the limitation period for a claim to recover an interest in land on the basis of unjust enrichment. In this newest case, the Court of Appeal takes the position that no, the Trustee Act and its 2-year limitation period governs in respect of torts, in respect of wrongs, and that unjust enrichment is a form of a wrong, and therefore, by implication, the Real Property Limitations Act is ousted in favor of the Trustee Act, and now we have a 2-year limitation period that's on par with the Limitations Act 2002. Now, I think that actually there are some issues in the judgment by the Court of Appeal, specifically in respect of the characterization of unjust enrichment as a wrong, and that seems to be, to me, at odds with the judgment of the Supreme Court of Canada in Garland Consumers Gas, which is the judgment that recognized that unjust enrichment is an independent, non-parasitic form of action. Doesn't Not parasitic on a common law doctrine or an equitable doctrine, and that's something else. We can say now that there's a 2-year limitation period for will challenges. There's a conventional 2-year limitation period for conventional litigation involving estates. And where there are wrongs, there's also a 2-year limitation period, which would seem to cover claims based on unjust enrichment, which is going to be the way that going to be an attack on assets in the estate involving land. This topic is worthy of a seminar, in itself, and I'm only scratching the surface of it at the invitation of the organizers of this program. I would hope that the legislature, in its infinite wisdom, decides to amend the Real Property Limitation Act, the Limitations Act 2002, and the Trustee Act to provide greater authority. The point that the Court of Appeal made in the Ingram case is that the need to administer estates conventionally within a short period of time is an important one, and it's not pragmatic to force the limitation period to remain open at great inconvenience to those that are interested in the estate. And that must be right. I mean, that policy, it has to be correct. And one would hope that the legislature will turn its mind to dealing with the legislation to provide greater clarity, and whether it chooses to do so within the Limitations Act 2002 or another statute is up to the legislature. I believe I'm out of time. Thank you very much kindly for your attention. I just want to do one more thing before I leave, and I'd like to say specifically hello to my friend Ian Hull. And Ian, this one's for you. Have a good program, everybody. Bye.